Good morning, everyone. Good morning, Mr. Schuster. Thank you for joining us today to record this web conference. So I'm Karima Smouk. I work at the Cyberjustice Laboratory. We are a research center at the University of Montreal working on the modernization of the justice system. We are interested on how technology can improve the justice system, can improve access to justice, and also can change the practices in the legal field. We started in 2017 a project called Autonomy through Cyberjustice Technology and AI. And basically, we are interested on how technology is implemented in the legal field and the justice system, how it can modernize the system, and also how technology can change some practices. We also study the technology with a critical approach, and not only just to implement it right away without understanding it and knowing the challenges around it, and making sure that everybody is aware of all the aspects of the technology and what it implies to implement that kind of technology. So this is important for us to have that kind of conferences talking about technology indeed, but in a way that brings the critical aspects on the table. Thank you, Edmund Schuster, for joining us this morning from London. So you're a professor at the London School of Economics, and today we're going to talk about blockchain and your paper about Cryptoland you published in 2019. So for the viewers, you can find the link to the paper in the description below. I'm going to let you present first, and then we can have a small discussion. So thank you. Over to you, Professor.
Great. Thank you very much for inviting me. So as you just mentioned, my presentation is about kind of the legal aspects of blockchain technology, and it's based on an article that is available on SSRN. You can see it, the link on the screen here, and this is forthcoming in the Modern Law Review later this year. I'm going to assume that you will have heard about blockchain technology. Really, who hasn't? But I'm not going to assume too much in kind of technical knowledge. If you have heard about blockchain technology, and if you just follow news online and various organizations promoting the technology, you might ask yourself, is there anything that cannot solve? So these are just a few examples. Blockchain has been proposed as a solution for money and everything to do with the financial system. Recently, some people have suggested blockchain could somehow solve the coronavirus epidemic. It could solve problems have to do with conflict minerals. And in the United Kingdom, Brexit, or the UK's withdrawal from the European Union, is a big topic, of course, and various aspects of Brexit have been looked at by blockchain advocates, and again, blockchain technology has been proposed as a possible solution. If you look online, and this has thankfully died down a bit, there are also a bunch of completely ludicrous projects out there. Jesus coin, a Ponzi coin that says it's a pyramid scheme, a university that said it wants to build a university on the blockchain, where basically the university administration is replaced by some blockchain project. And this all like 2 years ago, so this got also mainstream and interesting that even North Korea started a blockchain, an international blockchain conference. This is about the time that I got involved in, and we have important celebrity endorsers of the technology. Now, around the time where blockchain became much hyped, I could also notice that most of my lawyer colleagues and friends got really interested in the technology. Some of them actually understood the technology and found aspects of it fascinating. But most people I talked to, they just kept hearing about blockchain technology in various seminars and presentations without really understanding what it is going to do. And a number of law firms and financial institutions have started research and writing papers on this topic. So what I want to do in my presentation, what I try to do in my paper, is give you kind of a very brief introduction to the technology itself, and help you understand where this hype is coming from. But perhaps more importantly, I want to give you an idea of how a lawyer can look at this technology and compare it to things that we are already familiar with, and then assess how realistic those promises really are. Now, in doing so, I will try to give you a conceptual framework for how to think about blockchains, and then define how crypto assets and smart contracts can be looked at. I conclude that crypto assets and smart contracts are pretty much pointless for reasons, for legal reasons that I will describe later on. And we'll come to that, but let me just start with kind of a view of blockchains from a legal perspective. Now, as a lawyer, you could say there's the physical world, and in the physical world, we have value that is embodied in physical objects. So you can think about, you know, an apple that is a physical object, and the value of that apple is embodied in this object itself. Now, the same is actually true, to a certain extent at least, for cash. So cash is a physical object, but there is some value embodied in that physical object, even though it's not as clear as in the case of an apple, because people generally value cash. You can make a similar argument. Now, what this allows us to do is peer-to-peer transactions. So if I have an object, a physical object that already embodies some value, then I can just hand over that object to you, and we will have the opportunity to enter into such a peer-to-peer transaction. We don't need the involvement of any central counterparty. We don't need anyone to stand in the middle between us to make this transaction happen, because I can just initiate the transaction myself. I hand it over to you, and you receive it, and the transaction works in this very simple peer-to-peer fashion. There's actually no risk, at least initially, there's no risk of a so-called double spending. So if I give an apple to you, you don't have to worry about me also giving that same apple to somebody else, because obviously I cannot just duplicate the apple that I hold in your hand. And so by handing it over to you, a double spending is prevented, and it's kind of enforced, you could say, by the laws of physics. Now, because there's this useful feature of having physical possession of an asset or an item, all legal systems, both common and civil law systems, have kind of made use of that, and they say, well, there's a correlation between possession and legal rights, so we will give a special privileged position to possession in our legal systems. Now, we also have a different world, you could say, the kind of non-physical world, so general intangibles, but that also actually extends to the kinds of legal rights where physical possession is just not a very useful concept, such as, you know, land, real estate. Possession is far less useful and is far less correlated with legal rights in the case of a building or a plot of land than in the case of an apple. If I have it in my hand, it's probably mine. If I sit in a building, that doesn't really imply very strongly that I'm the owner of that. So if we look at these non-physical objects and registered rights, then we often use the terminology that is more fitting for physical objects. for tangible objects, you know, you can steal a movie or steal, I don't know, a song by downloading it and so on. But of course, when it comes to digital assets, so any digital representation, we have the problem that digital representations are, by their very design, non-unique. If I have, I don't know, a song, then I can copy that song and I can send it to you and then still have it. If I send an email to you and then I realize that I didn't want to send that email, this may be very upsetting for me, but there's absolutely no point in me asking you to send back my email. Obviously, if I send you an email, I still have it, and if I ask you to send it back, you would probably think that I'm a bit crazy. So when it comes to legal rights, and we have this non-physical world, we have generally two ways of dealing with them. One is we do engage in peer-to-peer transactions, but then we need to trust each other to a certain extent, at least. So for instance, if I tell you I want to assign my right to receive rent from somebody, I assign that right to you, then you need to trust me. If we do that in a peer-to-peer fashion, you need to trust me that I actually have this right, and therefore there is something, there's some valid assignment that can happen. Alternatively, and we do that for many other things, we can also say, let's just not bother with peer-to-peer transactions. Instead, let's just have somebody in the middle. Let's have a central ledger. Let's have somebody who keeps the record. And all transactions can then go through that central record keeper. And as long as we do that, we don't have to worry about double spending, because if I transfer some intangible to you using that central record keeper, and then I try to transfer the same asset or item again, then I will be unsuccessful, because the central record keeper will simply tell me, you've already spent that, or you've already transferred that, you no longer have control over it. Therefore, your instruction to transfer is no longer valid. We do that, for instance, very often with securities. So I don't, if I buy a share of Microsoft, I don't get this physical certificate. And if I sell it, I don't have to hand over anything. That is done by, in this particular case, a range, kind of a series of different central record keepers. Now, what about cash? Now, if you look at what I've just said, it seems like it's not really possible to replicate cash digitally. Now, we have to distinguish money from cash. Of course, you can have a PayPal account, or you can have a bank account with online banking, and then you can transfer online, you can transfer some cash. But all that happens here is that you go through a central record keeper, the bank or PayPal or whoever it is. But when you think about cash, you know, this idea to transfer value peer-to-peer, that doesn't seem to be possible here, because we can't really do what I call option one here, peer-to-peer and some trust, because the whole point of using cash is that I don't have to trust you or I'm not exposing myself to your creditworthiness by accepting your cash. So digital cash is hard. In 2008, somebody or a group of people called Satoshi Nakamoto, they published a white paper, and in that paper they describe a process for creating a digital or electronic cash system. So something that can replicate the world of cash, but in the digital realm. So I won't go into the technical details, but it's kind of useful to know that there are two technologies, two ideas that have been around for a long time that are underlying this technology. One is hashing, and all that hashing really is it gives you a way to digest information, to create a shortened version of that information. Ideally, you design it such that if you give me a slightly different input, you will get a very different output. And ideally, it looks very random. It's not easy to break. And so for our purposes, all it really does is it gives us something that is irreversible, at least in practice. So what a hash is if I give you a hash, then you will not be able to somehow figure out what I did in order to get this hash. So if I say to you, here's a hash, and a hash is just a string of numbers and letters. Here's a hash. You will not be able to tell me which document I used to create this hash. So I could give you a hash of, I don't know, my will, or I don't know, a contract, and you wouldn't be able to reverse it. You wouldn't be able to create the contract or the will or whatever document. At the same time, I wouldn't be able to use or to create another document that creates this hash. So in that sense, if I give you the hash and then at some later point I show you the document, you can be sure that whatever I did, this document created that hash. So it's irreversible. But at the same time, it gives me a certain proof. Now, a very simple analog, you could say, is a checksum. So if you look at your credit card, the last digit of your credit card isn't actually part of your credit card number. It's calculated by just adding up all the other numbers in all the other digits in your credit card number, and that is supposed to just avoid typos when you type in your credit card number. And so it's a similar way. Of course, it's more complicated, but it's similar in that you have a small output that summarizes a bigger output. Of course, in the case of a credit card checksum, it's very easy to come up with other credit card numbers that have the same last digit. In the case of a hash, it's not. Now, the second principle, and many lawyers will probably have come across this already, is a digital signature. And again, it's not important how this works technically, but it's similar in a sense to a traditional signature. And the key features here are, if I digitally sign a document, then it's not possible to somehow cut out that signature. So, take this digital signature and then attach it to some other document. So if I send you a contract that I digitally sign, you would not be able, if the signature is implemented correctly, you would not be able to then change the contract and somehow make it look like I signed that other contract, that other changed contract. So a digital signature gives me a way to prove that I signed this particular document by proving that I have knowledge of a certain private key, which then corresponds to a public key. So what I could do is I could say, my name is Edmund, and you can look up my public key, my public identity on my website, and then I'm the only one who knows this private key, and using this private key, I can sign all sorts of things. And then you can look at a document that I signed, and you can say, okay, so here's Edmund's public key. Yes, this signature really proves that Edmund, or somebody else who somehow has access to his private key, read this particular document, not a different version of it, this particular document, and signed it. Now, if you look at the problem that we have with building a blockchain, you could say, well, one big problem is the problem with time, right? I mean, imagine you have a system where, because we can use digital signatures, I could always just send you an email saying, I have 10 whatever coins or shares or whatever, and I just send you an email. And in that email, I say, I hereby sell to you my 10 shares in this company or whatever, and then I digitally sign it. We don't have a problem verifying that this email actually comes from me, that I actually signed this email. What we do have a problem with is that there's no way to check whether I haven't also transferred the same shares to some other people. So that is the double spend problem I mentioned earlier. Now, that wouldn't be such a big problem if we could just figure out who did I sell or transfer my shares or coins to initially. So who came first? As long as I somehow can find this out, I could just say, well, the first transaction is valid and the second transaction is the double spend and therefore is invalid. The problem with that is that there's just no objective way of ordering these digital events. I mean, to a certain extent, there are physical limits to how you can objectively order events, but even if we ignore that, due to network outages, lags, the distance, the physical distance between two participants, it's just not possible to objectively make sure that you know in which order two events took place, two messages were sent. Now, how could we solve this? Now, think for a moment about what your bank would do. Let's say you have two debit cards, and those two debit cards, they are somehow linked to the same account. Now, let's say you have $100 left in your account, and that is all you have, and you can't, you don't have any overdraft. What you could try to do is you could use your two debit cards and try to withdraw those £100 twice at almost the same time. You find two ATMs and you put them, you press the buttons simultaneously, and you try to get out $100 twice. Now, you obviously can't do that, and that is not because somehow magically the bank knows which which machine had the button pressed first in some objective way. The bank doesn't really care about it. It just says whoever sends us the first request will get 100, and whoever the request we see second, whether it was first or second, we don't care. The first instruction to pay out $100 we will comply with, and the second we will deny. Right? And so in a similar way, we could say, well, all we need to do is we build up some ledger, some transaction history. Doesn't matter whether it's objectively the right ordering of the transaction. We just make sure that there's one specific way of ordering those transactions that works. And this is basically what blockchain does, rather than appointing somebody like the bank who then decides which instruction did they see first. What a blockchain, at least a blockchain of the type that Bitcoin is based on, what they do is they say, well, let's just make writing those histories, those transaction histories, really, really expensive and also rewarding, although that's not as important in this context. And the way Bitcoin does that, and some of you may have heard of kind of the energy consumption of Bitcoin. The way Bitcoin makes writing those histories really expensive is it starts off every 10 minutes. It starts off a puzzle, a competition to solve a particular puzzle. And this puzzle has to do with the hashes I mentioned earlier. It's an otherwise pointless exercise of trying to find some input that would then create a certain output. And people participate in this puzzle, in this race, by just trying out a lot of different inputs and looking at the outputs until they find something that looks like the output that we are looking for. And because this is a race that is going on all the time, people have an incentive to try and only include transactions that are valid. And in this sense, in this context, what is valid, it just means that all transactions that we include in our history are actually transactions that are signed by the right person, and that are valid in the sense that the person who signs the transaction has enough coins or whatever. So this is a very non-technical kind of overview. Now let's look at what we said earlier. If you have some non-tangible asset, we said you can have peer-to-peer transfers with some trust, or you can have a central record keeper. And so in a sense, what blockchains do is they create an alternative to that, and a third option here. And they just say, we can actually have those digital transactions happen without trusting each other and without having a central record keeper. So I think for a lawyer, that's really all we need to know, that blockchains allow us to replace the central record keeper with technology that uses cryptography in order to create an outcome that, while typically very wasteful, in effect gives us results that are similar to to what we would get with a central record keeper. Now, you can then say blockchains replicate what we have in the physical world, in the online or digital world. It's not quite as useful as a normal peer-to-peer transaction because everyone needs to be online for it to work, but very useful nonetheless. Now, if you look at this, you could say, well, that's nothing really new. It's kind of, we're tokenizing assets, and we've been doing that since, you know, Middle Ages. If you look at the history of the negotiable instrument, what happened there was, I talk a bit about the history of that in the paper. Essentially, some merchants in 500 years ago, they started saying, you know, if we have those claims against each other, wouldn't it be useful to just write them on a piece of paper, and then let's just collectively pretend that this is no longer a piece of paper, but actually that this physical object, a piece of paper, which in itself is worthless, represents valuable rights, claims for payment, and so on. And this was done and worked fairly well among the merchants. At least the common law had some difficulties initially to adjust to that convention among merchants. But after some time, the law just accepted that this is really, really useful for the merchants, and they basically let them do it. So rather than having transfers of those valuable rights according to the rules that would usually apply to the underlying right, they accepted that those transfers can happen in accordance with the rules for physical objects, at least to a large extent. Okay, so with that in mind, what I do in the paper is I define what I mean by crypto assets. And I say, well, there are really two different types of crypto assets. One type is what I call a naked blockchain. It's a blockchain where whatever is recorded on the blockchain is self-contained in the sense that it's kind of comparable to the merchants starting to care about the actual pieces of paper rather than anything that is represented by that. So the best example, of course, is Bitcoin. So you have something that has no physical equivalent or no, you could say, real world equivalent. But there are some other examples. People use blockchain systems. They have elaborate systems where the blockchain system itself fulfills some file sharing and file saving functions where everything that happens really happens on and in the blockchain. And the same is true for the so-called CryptoKitties, which is basically a game where you use a blockchain to create cute-ish looking kitties that are digital representations. Now, I'm not so interested in that. I'm not so interested in these types of blockchain use cases. I'm more interested in everything else. And so what I'm saying is, for every blockchain that is not naked in this sense, so for any blockchain where it isn't the case that everything that happens on the blockchain, but the case that is more interesting to us lawyers, where something on the blockchain is somehow connected, linked to the legal world, and where tokens stand in or represent something, all these other cases, I call them crypto assets. And my argument here is that whenever that is the case, whenever something on the blockchain stands in for something happening in the real world or that has some legal reality to it, we run into a problem. And that problem is we need to somehow link up whatever happens on the blockchain with what I call legal reality, because otherwise the blockchain assets, the crypto assets, will not fulfill their purpose. Now, I'll explain that in a bit more detail in a second. I just want to also introduce this idea of smart contracts. Once we have a blockchain that allows us to transfer tokens around, it's also possible to just extend this system a bit and add some functionality. And whenever we do that, this is typically referred to as smart contract. Now, a smart contract is in a sense comparable to an Excel sheet. So in some types of transactions, lawyers actually attach Excel sheets because calculations are difficult and so on. And so they say, you know, the contractual rights of the two parties shall be represented by the attached Excel sheet in certain situations. So smart contracts are similar to that. The main difference is that the kind of smart contract that people talk about, in those cases, the rules of that Excel sheet or the code behind it is public and can and should be executed and validated by other parties. So that is not, of course, the same as happens in your relationship with your bank. My bank sends me mortgage statements, and I know that nobody is sitting there with pen and pencil calculating how much I should pay. Of course, I understand that, but at the same time, I have access to the codes, to the calculation, to the computer system they use to calculate that. Right? So smart contracts are comparable to this computer program that the bank runs to calculate your mortgage interest, but the difference being that the content of the agreement itself contains the code that is then used to calculate it. Now, as long as everything is completely self-contained within this protocol, you could say this contract is then self-executing, meaning that you enter into the contract and everything, the whole execution of the contract itself is then a matter of the computer program running. The problem is there is nothing where there is no use case where everything that happens, everything that is subject to an agreement of a smart contract is completely self-contained. So at least I have never seen anything that comes even close to that. The second problem is that we don't actually need smart contracts to make use of technology. We already do that. I use in my paper, I use as an example public transport in London. In London, I have a debit card, and whenever I enter our tube, our underground, I just hold my card there and the gate opens automatically. In a sense, that is the electronic, the digital execution of an agreement between me and the public transport provider. But of course, not every aspect of the relationship is coded in the gates itself, but a part of it is executed in that way. So what smart contracts really add here is that you don't have to trust your counterparty. So I don't have to trust my public service provider because I can audit the code myself. I would say this is kind of solving a problem that nobody has ever had, because as far as I'm aware, people don't typically have this trust problem at the outset of entering into a relationship. Now, I'll come back to the kind of computer code versus natural language a bit later. I just want to introduce here another problem, and that problem is the so-called Oracle problem. Whenever you have anything happening in the real world that should then have an impact on how contracts are performed, which is the case if you think about it for every contract that means anything, then there's, no matter how trustless you make the code, there's always the question of who provides those inputs, who feeds those inputs into the computer system itself. And so even if you eliminate trust on the system itself, it's very hard, it turns out to be very hard to eliminate trust in kind of the inputs that go into the computer system. So think about, you know, a mortgage payment where the interest rate you pay is linked to some reference interest rate. You need a way to feed the reference interest into the system, and whoever you choose as the person who can feed in that information, you at least need to trust that person, because otherwise you can just enter and insert random values here. Now, I come to kind of my central argument here. My central argument is a very simple one. It's the central argument in my paper is based on, I think, the self-evident fact that if you have crypto assets that have some real-world application, real-world reality, that are part of the legal system in some way, then you need to rely, at least in principle, on the legal system. Now, one problem is that every legal system puts limits, places limits on what you can agree. So there will always be exceptions in every legal system. And there will be rules that say certain types of transactions, certain transfers cannot happen. If I hold a gun to your head, no legal system will say, yes, something that you transferred over to me, actually, you actually validly transferred title to me, and so on. And there are many, many other examples. There are questions about capacity, there are exceptions for fraud, and in private international law, there are ordre public exceptions, and so on and so on. So you have a situation where you need to rely on the legal system, you need to link to that legal system, and you have a legal system that prevents certain agreements from entering into force. Now, of course, I hope that is not controversial. There's just no way to fully encode all legal rules that prevent the validity of a transaction, to somehow code that in a way that the computer can distinguish between valid and non-valid transactions, right? So I'm not just saying that kind of self-servingly because I'm a lawyer and I don't want computers to replace all lawyers. I think it's kind of self-evident in our world that we're not in a position where a computer program can somehow distinguish between a transaction that a judge would regard as fraudulent, distinguish between such transactions and transactions that are not fraudulent. That's just not possible. Now, as a consequence, whenever you want to put anything on the blockchain that has some legal reality, you need a system to make sure that there's a realignment of the legal system with the blockchain. So the blockchain must, in a way, synchronize with the law. So what I use as a comparator here is that imagine you have two different ledgers, two different tables. One table says one table is the blockchain, one ledger is the blockchain, and the blockchain assigns to different people assets. Let's say we have a blockchain register of shares in a company. Then I look up the blockchain ledger and it will give me shares, a column with shares and a column with people, and then I know who has how many shares on the blockchain. And then we could imagine the same being true for the law. There's no explicit ledger, of course, but we could say, well, it's a legal question, who owns how many shares of that company, and I can ask the legal system to give me an answer for each and every person, and in most cases it will be clear whose shares those are. Now, imagine a situation where the blockchain and the legal system do not synchronize. We have a situation then where, for instance, I fraudulently somehow convince you to transfer some shares to me. From the viewpoint of the legal system, it will typically be the case that legal title will not have passed, and so no transfer of ownership has happened. But from the blockchain perspective, the blockchain ledger will have been updated with the transaction, because the blockchain itself cannot distinguish between fraudulent and non-fraudulent transactions. So if we don't synchronize the two, so if we don't correct the blockchain, then what we end up with is a ledger, a blockchain ledger, that will slowly drift apart from the legal reality. So we will end up with something that is mostly right, but not always right. And people will realize, because this error can keep feeding down from this particular transaction, slowly the two will drift apart. And very quickly, people will say, it's actually not very useful to rely on this blockchain ledger, because no errors can be, even known errors cannot be corrected or are not corrected in practice, and therefore I should not rely on the veracity of the record on the blockchain. Now, I think it's fairly uncontroversial that for legal assets you need some sort of synchronization. So the question is, how do you do the synchronization? The easiest way to synchronize is to just give the state in some capacity, maybe judges or however you want to design it, a super key, some way of overriding the state of the blockchain, and say, once there's a valid court judgment that says this transaction was invalid, we just reverse whatever happened on a blockchain. Now, if we do that, then of course we're creating something completely pointless, because what we're doing is we first invest a lot of kind of time and energy in creating a decentralized system where we don't need a central record keeper, and then we reintroduce at the last stage a central record keeper who has the super key. We might as well just have a centralized database, as we use in many other contexts, to start with, and it would be much more efficient. You wouldn't have to have all this expensive calculation stuff. Now, also, even if you somehow manage to have a blockchain system that doesn't waste a lot of energy and time, then you would still not actually create anything new. It's like saying, let's all write all contracts in red ink from now on. Yes, it's a different system. It's probably worse because red ink is more expensive than black ink. But even if you can make red ink as cheap as black ink, you wouldn't actually enable anything that we couldn't do previously. So that's probably not a good idea. Again, I think that is really uncontroversial, because people who like blockchain generally don't like super keys for the state anyway. Now, you could try to find some anchor jurisdiction, some blockchain-friendly state or country that adopts a law that says whatever happens on the blockchain is automatically also reflective of our legal system, and then we just all choose voluntarily, by entering into this world, we choose the law of that country and accept that. The problem with that is that private conflicts of law rules prevent us from choosing a law to the extent that it would result in transactions that are against the public order that are given effect to. So if some country says, even if you hold a gun to somebody's head, as long as they sign a transaction on the blockchain, that title will have passed, then even, I don't think that any country would be silly enough to do that, but even if they did, it wouldn't actually help, because outside of that jurisdiction, you couldn't rely on the relevant choice of law here. Now, alternatively, you can have something like oracles, so people who observe what's happening in the legal system, and then they somehow, so it's not the state itself, it's some oracle, some other people who do that, but it leads to the same problem. Then you actually need to trust the oracles, and then if you have somebody that you trust, like the oracles, you might as well just ask the people that you trust to be oracles to keep your central database. I also explain in the paper why kind of adjudication on the blockchain or governance solutions are not ways to solve this. So I then come to the conclusion that you have to choose between two very unappealing situations. You can have a centralized blockchain system. So a blockchain system where you use a blockchain, but at the same time you give somebody or a group of people centralized super access, so they can change what is on the blockchain, in which case it's kind of pointless to use a blockchain in the first place, because you could just ask the same people to run a traditional centralized database, which is quicker and cheaper. And in any event, you don't enable anything that isn't available already. Or you do it in a truly decentralized fashion. But in that case, if it's truly decentralized, you can't actually ensure that there is this synchronization with the legal system. And if you can't ensure this synchronization, then whatever your tokens are, they will be useless as representations of the legal underlying legal assets. You can kind of trade off between those two extremes and make it a bit less pointless, but then a bit more useless. But you know, if your trade-off space is between pointless and useless, I argue it's probably not worth doing it in the first case. Now, I then discuss the possibility to solve this by just adopting a legal fix. So implementing a very blockchain-friendly law that makes it easier to, or that removes the necessity to sync up those systems. And I conclude that this is not going to happen. And the reason why it's not going to happen is not just the experience we have with some countries that said we will pass and that have passed laws that are designed to be blockchain friendly. All the laws I've seen, they do very little, or they actually explicitly exclude things like fraud and you know, hacking and stuff. And so they're not actually fixing the problem. But perhaps more important, we have to look at the costs and the benefits. And as all lawyers know, we don't really sit around and sue people for obligations that are crystal clear. It's typically a bit more complicated than that. And so the range of things that you can actually speed up and solve with smart contracts is extremely, extremely narrow. So because there are very limited benefits, as I discussed in the paper, it's unlikely that we will see this change. And I think it's important for lawyers to also understand that some of the arguments, they really stem from this idea, fairly common among technologists, that lawyers are somehow just too stupid to use very precise language. So they look at language and they conclude that, you know, computer code is so much is more precise in expressing ideas that there's just no point in using. Sorry, I'm having they conclude that there's no point in using natural language. And so actually, this is a bit naive. In a sense, the language we use as lawyers is a very specific type of language. It's arguably something that is the sweet spot that we found over centuries of trying out, where you define or use a language that is more precise than the normal informal language that we use in everyday conversations. At the same time, it's much more flexible, much more open-ended, much more useful for legal contracts than a purely formal mathematical language. There are instances where it's very useful for lawyers to use extremely precise expressions, and I've worked on transactions like that. It's very easy. You just have some text, and then you say, well, I don't know, the payouts in this case are calculated as follows, and then you add a mathematical formula. So there are cases where for certain aspects of an agreement you need very precise language. For most other things, it's just useful to have a language that is less formal than mathematics, to have, you know, reasonable care or reasonable efforts or best efforts, concepts that are just not easily defined in precise terms, but that are more precise than me saying I'll do my best in a normal conversation. And so if you look at blockchain promises, they often or almost always suffer from what I call the junior business consultant fallacy. They look at our system, whatever it is, you know, the financial system, the registries or whatever, and then they just say, it would be much better if we could just all switch to my new blockchain system. And that is absolutely true. It's always true what they say. The problem is not that it isn't true that it would be more efficient to switch to this one system. The problem is that switching to any new system where everyone switches over, if you can somehow force everyone to adopt one single system, of course the world will be better, right? Of course the world will be more efficient. The problem is that it's very hard to make everyone switch to another system. More importantly, if you can have everyone switch to another system, then you should look at all the systems that are available in that case. And so saying that switching to the blockchain, to a blockchain-based system, is better than the status quo is meaningless. Any change to any system that is adopted by everyone will be better. And I have not seen a single project where using the right comparator, namely all the systems that are available given the change that we already demand by proposing our system, where blockchain then offers any kind of unique or valuable solutions. Having said that, I think what blockchain technology may have done is it made it more interesting for senior executives to think about kind of back office technology, and so maybe that in itself drives some useful change. I've probably spoken for a bit too long now. My conclusion in the paper is if you have permissionless blockchains, they are just incompatible with the legal system. In a sense, what I'm saying is a permissionless decentralized system is defined by the absence of hierarchy. So you don't have a hierarchical system because you're decentralized. But if we look at our system and we describe it as the rule of law, then the rule of law requires a hierarchy. You can't have a rule without a hierarchy. And in that case, it's the law that kind of is in this top spot within the hierarchy. And so the law is therefore incompatible with real decentralization. If you re-centralize to solve this problem, and that applies equally to these enterprise blockchains that are often proposed, then you kind of render just the whole technology pointless. There's nothing left. If you then re-centralize, you could just do it in a centralized database to start with. And the same argument applies to smart contracts. And as I said earlier, I don't think that law will or indeed should adapt to the extent necessary to make those chains work. Thank you.
Well, thank you very much. It was very interesting. I'm not familiar really with a blockchain, but I really enjoyed it. It was very very clear and not too much information that my brain cannot process. So I have a few questions. I want to ask, do you think that the obstacles of the implementation of blockchain are coming from the genesis of blockchain technology, of why it has, when and why it's born actually?
So I think the way it was conceptualized initially for Bitcoin doesn't actually suffer from the same kind of problem, because in a way, whether or not the legal system endorses or accepts a certain state of the blockchain is irrelevant, in the sense that everything that happens in a blockchain transaction happens within the blockchain itself, right? So there are still interesting legal questions there about enforcement and so on, but it's not obvious that incompatibility with the legal system renders the whole Bitcoin system useless. I don't think that this argument is easy to make. In that sense, kind of the way this was conceptualized initially as a cash alternative, it suffers, I think, from its own problems, but those problems are not primarily legal. The legal problems arise when people look at this and say, wow, this is exciting, But we don't actually want to create a new kind of money that is outside the control of any state, because we're not actually that interested in that stuff. What we want to do is use it for other stuff. Right? And so when people use it for other stuff, they overlook the fact that even if I have, let's say, blockchain token shares, and you somehow steal those shares from me, then what I will do is not necessarily somehow try to change the blockchain. I will just go to court and say, this company should not pay dividends to her. They should pay dividends to me because, she had a gun to my head when I signed this transaction. And I will probably prevail, right? And so the blockchain is just, the system is, in my view, therefore, incompatible with linking it up to something that is fundamentally within the control and subject to the enforcement by state authorities.
But yes, that comes to my next question, is that actually I'm in the technology and law too, and I kind of realized that sometimes we try to implement the technology in a way that it actually, yes, it replicates our reality and is compatible with the real world. But what if actually that kind of technology is understood and used and implemented in a way that we fully and consciously understand that it's an alternative of the real world, and for that we won't go through the same legal routine and all that stuff. What do you think?
So I think your question really is, what if we just ignore the legal system, right? Wouldn't that work, right? So in a sense, you could say, at the time of Napster, saying Napster cannot work because these file sharers don't have permission to share this song or something like that is kind of a silly point. Yeah, you might still have this big network, and it might actually be used by people, right? And so in a sense, I think your point is exactly what makes pure cryptocurrencies work, right? So it's not really that relevant to what extent the state endorses Bitcoin or any other cryptocurrency, right? As long as people kind of like it, the fact that from a legal perspective some transfers are not valid or something like that may not, or does not necessarily mean that people will stop using it or even care about what the system says, right? So clearly, I don't know, the most ransomware attacks where they encrypt your computer's contents and then want some payment from you, most of them demand Bitcoin payments. Clearly, from a legal perspective, blackmailing somebody with something like that and extracting a ransom in that way clearly doesn't lead to any legally enforceable or recognized transfer of anything. Right? But as a matter of fact, it works. So these people do it because they know you will send them some Bitcoin and they will find somebody who gives them. What I'm saying is, yeah, to a certain extent for this stuff, you can ignore it. You can ignore the legal system. But you simply cannot ignore it where the core of what you try to do is subject to legal enforcement, right? Because you would need some sort of an understanding among all parties not to use the legal system. And this is just implausible, right? Even if you're a devoted anarchist, right? Once you could just go to court and get back, I don't know, $1 million. It's very unlikely that you will say, yeah, but that's kind of incompatible with what I agreed to, even though it's not legally binding, right? So the fact that everyone always has the option of using the legal system means that being outside that legal system while at the same time trying to transact in assets that are subject to the legal system and subject to legal enforcement, in my view, means that it simply cannot work.
Okay, so what is your advice to lawyers right now about the blockchain technology? Should they prepare themselves to be confronted to it, like through smart contracts implementation, for example, or no, just let it go?
So I think I don't want to give any advice to people who have already invested significant time in that, simply because they presumably know what they're doing. I would rather try to give some comforting words to the people who haven't yet, and that is, it may have felt over the past 2-3 years like you really should understand this because everyone is talking about it, but somehow you couldn't be bothered. And the comforting words are, there's no need to understand this. This will go away, and I don't think anyone will care about this. At least there won't be, in my view, the kind of shift towards that system that makes it in any way, shape, or form essential for a normal lawyer to understand this stuff in detail and to try and really get into that.
Okay, so well, goes. It went well. It was very interesting, and I want to thank you again, Mr. Schuster. And
Thank you for having me.